This is a legal passage going at 120 words per minute. Let us start. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court of Gujarat and Ahmedabad in criminal miscellaneous application number 1 of 2018 in special criminal application by which the High Court has dismissed the said application preferred by the appellant, herein permitting him to be joined as respondent in the said special criminal application which was filed by the private respondent, herein seeking further investigation against other persons other than the applicant, who is one of the accused and is already charge sheeted. The appellant has preferred the present appeal. In an earthquake in the number of buildings collapsed, including the building named Shikhar Apartment, situated in a village in Ahmedabad, that due to the collapse of the said apartment, 98 persons died. The private respondent herein, the victim lodged first information report with the satellite police station against the appellant and others for the offences punishable under sections 304, 418, 420 and 114 of IPC and section 3, section 7 and section 42 of the Gujarat ownership of flats and for contravention of GDCR building bylaws. The police inspector, satellite police station, filed the charge sheet against the appellant and others on 2nd May 2001 for the aforesaid offences. It appears that after a number of rounds of litigations, the appellant and some of the other accused came to be charge sheeted. However, 3 accused persons were not charge sheeted. The matter was carried up to this court by way of criminal appeal number 1426 of 2017. It appears that during the hearing of the aforesaid appeal by this court, there was progress in the investigation and the charge sheet was filed against the accused Yagnesh Vyas and Sanjay Shah, who were also arrested. Therefore, while disposing of the aforesaid criminal appeal number 1426 of 2017, wide order dated 16th July 2018, this court observed that if the private respondent, herein the victim, has any objection against dropping of one another accused, he may file objection and can file a protest petition in the trial court. This court also observed that the private respondent, herein the victim, can also carry out proceedings in an appropriate court against one Mr. Bhumaik and for not prosecuting him. That thereafter the private respondent, herein the victim, filed an application before the learned Chief Judicial Magistrate Ahmedabad Rural under sections 173 of 8 and 156 of 3 Criminal Procedure Code for further investigation against Mr. Bhaumik. By an order, learned Chief Judicial Magistrate Ahmedabad Rural dismissed the said application on merits as well as on the ground that after the charge sheet is filed, the magistrate has no jurisdiction to order for further investigation. Feeling aggrieved and dissatisfied with the order passed by the learned Chief Judicial Magistrate, passed in an application in criminal case number 853 of 2001, the private respondent herein has preferred the special criminal application number 8704 of 2018 before the High Court of Gujarat. In the said special criminal application, the appellant, herein one of the accused who is already charge sheeted, submitted an application permitting him to be joined as party respondent number 4 in the said special criminal application. By the impugned judgment and order, Judge of the High Court has dismissed the said application. The learned senior advocate has appeared on behalf of the appellant. The private respondent herein has appeared as a party in person and other learned advocate has appeared on behalf of the respondent. It is further submitted by the learned senior advocate appearing on behalf of the appellant that the High Court has not properly appreciated and considered the fact that, as held by this court in the case of Atul Rao versus State of Karnataka, it is submitted by the learned senior advocate appearing on behalf of the appellant that even as already held by this court in the case of Shambhu Patel versus Suman Patel, the complainant does not have any right to file an application under section 173 of 8 Criminal Procedure Code once the charge sheet is framed. It is submitted that in the present case the charge sheet is already filed and the evidence of the complainant has been recorded, and therefore the learned Chief Judicial Magistrate was justified in rejecting the application for further investigation under section 173 of 8 Criminal Procedure Code preferred by the private respondent herein. It is submitted that if the opportunity would have been given to the appellant by permitting the appellant to be impleaded as a party respondent in the special criminal application, the appellant could have pointed out the aforesaid aspects and submit the case on merits. It is submitted that even otherwise, looking to the allegations in the writ petition before the High Court, as the private respondent herein has made allegations against the investigating agency that the investigation is not carried out by the investigating officer properly, the appellant being accused is a necessary and proper party, and in his absence effective adjudication of the subject matter of the dispute may not take place. Number of other submissions have been made by the learned senior advocate appearing on behalf of the appellant on merits of the application submitted by the private respondent herein for further investigation under section 173 of 8 Criminal Procedure Code. However, for the reasons stated herein below, and as the main special criminal application against the order passed by the learned Chief Judicial Magistrate rejecting an application submitted by the private respondent herein for further investigation under the aforesaid section is pending consideration by the High Court, we do not propose to go into the merits of the application submitted by the private respondent herein for further investigation. Sri Maninder Singh, learned senior advocate appearing on behalf of the appellant, has also heavily relied upon Rule 51 of the Gujarat High Court Rules 1993 in support of his admissions and submissions that as per the rule, all parties to the proceedings from which the appeal or application arises shall be made the parties to the appeal or application. It is submitted that therefore also, and as the appellant herein was a party to the criminal case number 853 of 2001, in fact, the private respondent herein ought to have impleaded the appellant in the special criminal application.